In this video, we will examine the Brady List, what it means for officers and other facts related to its implementation. What is a Brady List? The Brady List is the previous name for the potential impeachable disclosure policy and protocol, which includes police officers and others where there could be potential impeachment material in a court case. The Brady name comes from Brady v. Maryland, a United States Supreme Court decision stating that the government should not withhold evidence that could affect a defendant's guilt or punishment. Brady obligations is really a shorthand way of referring to three distinct but overlapping obligations of prosecutors to disclose potential impeachment material to defense. Some officers with potential impeachment material are still in the field making arrests and locating evidence. That decision rests with the police agency. For some agencies, those officers are not in the field, and for others, they are terminated. If a Brady List officer makes an arrest or locates evidence, we examine the case and decide on an individual basis if we can proceed. If we do file charges, we absolutely disclose the material to defense, regardless of if we decide to call that witness in trial or not. If our case rests entirely on the credibility of one officer alone who is on the Brady List, we'd examine that case very carefully before making a filing decision, and may decline to file because we feel we cannot sustain the state's burden. It is quite unusual for there to be a circumstance where a case rests entirely on the word of one particular officer with no corroborating evidence whatsoever. Most cases have some additional corroborating evidence such as other witnesses, officers, victim statements, as well as physical evidence, such as body cams, dash cams, surveillance cams, etc. It is not a regular occurrence for these officers to testify in trials. It is not a regular occurrence because for some agencies those officers are terminated, and for others they are not actively in the field making arrests or finding evidence. When it does come up, it is always disclosed to defense counsel and brought before the trial judge who decides on the admissibility of the impeachment material. Brady obligations is really a shorthand way of referring to three distinct but overlapping obligations of prosecutors to disclose potential impeachment material to defense. They are: the due process clauses of the state and federal constitution require prosecutors to disclose all material evidence that is favorable to the defense, including exculpatory information and evidence to impeach prosecution witnesses. Criminal Rule 4.7a(3) states prosecutors shall disclose to defendant's counsel any material or information within the prosecuting attorney's knowledge which tends to negate defendant's guilt as to the offense charged. The constitutional due process requirement for disclosure of exculpatory evidence is set out in Brady v. Maryland, 373 U.S. 83, 1983. This requirement has been explained and modified by numerous subsequent cases. Both the Washington Supreme Court and federal courts have interpreted these duties expansively. The United States Supreme Court in Kyles v. Whitley described the disclosure duty as follows. This means, naturally, that a prosecutor anxious about tacking too close to the wind will disclose a favorable piece of evidence. This is as it should be. Such disclosure will serve to justify trust in the prosecutor as the representative of a sovereignty, whose interest in a criminal prosecution is not that it shall win a case, but that justice shall be done, and it will tend to preserve the criminal trial, as distinct from the prosecutor's private deliberations, as the chosen forum for ascertaining the truth about criminal accusations. The prudence of the careful prosecutor should not therefore be discouraged. Kyles v. Whitley, 514 U.S. at 439-40, 1995. We are well aware of our obligations and error on the side of disclosure. The King County Prosecuting Attorney's Office policy says exactly that on page 1. A prosecutor's disclosure responsibilities derive from both the Constitution and from state rules. In Brady v. Maryland, 373 U.S. 83, 1963, the United States Supreme Court held that the suppression by the prosecution of evidence favorable to an accused violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. The duty to disclose exists even where a defendant has not requested materially exculpatory information, and the duty includes impeachment evidence. Strickler v. Green, 527 U.S. 263, 1999. The duty extends to information solely in the possession of investigators, meaning prosecutors are responsible for knowing what the police possess. Kyles v. Whitley, 514 U.S. 419, 1995. The prosecution does not have an obligation to disclose preliminary, challenged or speculative information. United States v. Agurs, 427 U.S. 97, 109 and .16, 1976. However, the prudent prosecutor will resolve doubtful questions in favor of disclosure, because it is extremely difficult to discern before trial what evidence will be deemed material after trial. ID at 108, United States v. Acosta, 357 F. Sub.2 D. 1228, 1233, 2005. Court and practice rules also address a prosecutor's duty to disclose information. Prosecutors are required by Criminal Rule 4.7, A.3, to disclose any material or information within the prosecuting attorney's knowledge which tends to negate a defendant's guilt as to the offense charged. Impeachment evidence is defined by Evidence Rules 607, 608, and 609. The rule-based disclosure obligations are broader than the due process right but are limited to material and information within the knowledge, possession or control of members of the prosecuting attorney's staff. CRR 4.7, A.4. Information supplied by law enforcement agencies to prosecutors is immediately subject to disclosure under this rule. Similar concurrent duties are placed on prosecutors by Rule of Professional Conduct 3.8, D. For a Brady violation to occur, 3 elements must be satisfied. 1. The state failed to disclose evidence that is favorable to the accused, either because it is exculpatory or impeaching. 2. The state suppressed the evidence either willfully or inadvertently. And 3. The undisclosed evidence was prejudicial. Citations for the case law will be in the description below.
The Brady List is not limited to just line police officers. Please watch the following video when a police chief was added to the Brady List for her alleged dishonesty regarding wearing her body camera.
PD Police Chief Jacqueline Villoreal is now being called into question because of what she said on the stand during a civil trial this week. A family is suing an LMPD officer who initiated a police chase that killed their 22-year-old son. 2 years later, the recollection of the LMPD police chief is being challenged. LMPD Police Chief Jacqueline Villoreal took the stand Monday in a civil trial. The case stems from a fatal 2021 police chase that killed 22-year-old Trayvon Mitchell. Mitchell was riding a moped in the California neighborhood July 6, 2021, when the suspect of the police chase refused to stop for police, drove into traffic, crashed into a truck, and ran over Mitchell, killing him. The estate of Mitchell is suing LMPD officer Ben Sullivan, the officer who initiated the police chase, claiming Sullivan's negligence led to the crash. While on the stand, the chief testified under oath that she was not wearing her body camera on the scene. She said if she was wearing her camera, she would have turned it on, which is LMPD protocol.
I don't want to insult you, but it's sitting right there. Anytime you're involved in a law enforcement activity, you're supposed to turn on your body camera. You were second in command,
correct,
responding to this violent, fiery crash. And
I was responding, but I was not actively engaged with any other citizens at that crash.
However, in a turn of events, the attorney for Mitchell showed proof Chief Gwen Villoreal was wearing her body camera, showing the jury a photo of the chief from the scene.
If you would have had it on you, you obviously would have turned it on, right? Because you were out there, you were interacting with the public, right?
I would have activated it if I had it on.
That's your story, you're sticking to it.
That's my statement.
I want to show the jury some truth and transparency.
Where's the footage, Chief? Did you delete it?
The chief responded, "I didn't delete anything." The mayor's office released this statement in response to the testimony. Quote, "After providing over 6 hours of testimony on an incident she responded to 2.5 years ago as then deputy chief, Chief Gwen Villoreal misspoke in response to a gotcha question from a lawyer trying to inflame the jury and drive up their own payday," end quote. The status of Louisville's consent decree was also a topic of discussion during the chief's testimony. The decree was ordered by the Department of Justice to implement change within the police department. The city has been waiting for a final agreement since March. That's when the DOJ released its report findings. In her testimony, the chief said the process has not even begun.
We have not received a draft consent decree to see exactly where their position is. We have not begun any negotiations, so with all accuracy and honesty, I cannot speak to this report in its fullness because we're still in the beginning, we're still at this process.
The city of Louisville is expected to pay upwards of $7 million to fund its consent decree.
Well, it appears that this chief was added to Kentucky's Brady List by a citizen. Ultimately, the duty to be honest is not just a professional obligation. It is a moral imperative that lies at the heart of policing in a democratic society. Police officers must recognize the profound impact of their words and actions on the communities they serve and strive to uphold the highest standards of honesty, integrity, and accountability in their daily work. Moreover, the duty to be honest serves as a safeguard against corruption and misconduct within police ranks. By holding themselves to the highest ethical standards, officers mitigate the risk of abuse of power, coercion, and deception that can erode public trust and tarnish the reputation of entire agencies.
Thank you for watching. We hope this better informs the public